discuss legal rules as to acceptance or essentials of a valid acceptance. The first rule, an acceptance must be absolute and unqualified and must correspond to terms of the offer. The acceptance must be absolute and unqualified. Unqualified means it should be unconditional. In other words, the terms of acceptance must be consistent with the terms of the offer. A conditional or qualified acceptance is no acceptance at all. If there is any variation means changes. Even of unimportant point, there is no contract. If an acceptance with a variation is no acceptance, but it is a mere counter proposal which is for the original offerer to accept it or not. Example. Let us discuss the example. First example, X offers his house to Y for lease from 1st April 2020, but Y accepts the offer provided the possession is offered him from 1st March 2020. It is not acceptance, but it is a counter offer. Another example, A offers B a house at rupees 1 lakh, but B is ready to accept to purchase it at rupees 50,000. This is counter offer. Another example, A says to B, I offer to sell my car for rupees 50,000. B replies, I will purchase it for rupees 45,000. So this is no acceptance and this amounts to counter offer. Another essential or legal rule as to acceptance, acceptance must be communicated to the offerer. An acceptance to be valid and legally binding, it must be communicated to the offerer. So it must be communicated to the person who has made an offer, that is to the offerer. Mere intention or mental determination to accept on the part of offeree is no acceptance, but the party entitled to get the communication of acceptance can waive or surrender the right expressly or impliedly. Means here acceptance must be communicated, and for the communication he must do some act for communication of the acceptance. On this point we are going to discuss the case law, Borden versus Metropolitan Railway Company's case. A draft agreement relating to the supply of coal was sent to the manager of railway company for his acceptance. The manager wrote the word approved and put the draft in the drawer of his table. He intending to send it to the company's solicitor for formal contract to be drawn up. Though due to oversight, the document remained in the drawer of the table. So it was held that there was no contract because there is no communication, though he was intended to send. But this was mere mental resolution, and that does not amount to acceptance because there has to be some external manifestation of the intention. He has to do require act, then and then only there is a communication of acceptance. A mere mental acceptance which is not evidenced by words or conduct is in the eye of law no acceptance. In order that the acceptance can be treated as valid, it is necessary that the same must be communicated to the offerer, either by the offeree or by some duly authorized person on his behalf. If the communication is made by unauthorized person, it does not result in a contract. So a contract will thus be binding only when the acceptor has done something to signify his intention to accept and not when he has only made up his mind. So there must be some external manifestation of the intention by speech, writing, or by other act. Then and then only the proposal is accepted. Third legal rule, acceptance must be given by the party or parties to whom the offer is made. A communication of acceptance to be valid, it must be either by the offeree himself or by his authorized agent only. A communication of acceptance by any other person will not be a valid acceptance. For example, A offers to B. C is a stranger. He cannot give acceptance. On this point, we'll examine illustrative case Powell versus Lee. The fact of the case, Powell applied for the post of headmaster in a school and his application was accepted by the school. Before the formal appointment, one of the board members had informally informed Powell of the decision, which was later rescinded or withdrawn by the board. The decision was that uh, he was elected. So that was the informal communication made by one of the member of the board. But this decision was later withdrawn by the board. So Powell, he sued the school for breach of contract. Held his action failed because the acceptance was not communicated by someone authorized and thus there was no valid contract. Fourth essential of acceptance is acceptance as per mode prescribed. The acceptance must be made as per or according to the mode prescribed by the offerer. Suppose X is asked to give his acceptance by wire, telegram, then X has to give his acceptance telegraphically. So the mode or the manner which is prescribed by the offerer, the acceptance must be given in the same mode. For example, on TV, we used to watch Surbi TV show, and here if a person and the person is required to send his answer by the competition postcard. So here the mode of acceptance was prescribed. So here the offeree has to accept the offer or give his acceptance in the same mode which is prescribed. Section 7, subsection 2 of the Indian Contract Act provides in order to convert a proposal into a promise, the acceptance must be expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it is to be accepted. Number fifth essential, acceptance must be given within a reasonable time. The acceptance must be made while the offer is still in force, that is before the offer lapses. Acceptance made after the offer has been withdrawn is invalid acceptance. If any time limit is prescribed in the offer, it should be accepted within that prescribed time limit only. However, if no time is prescribed, it must accepted within a reasonable time. And what will be the reasonable time depends upon the circumstances of each case. It differs from case to case. Example, M offered to take shares in our company on June 8. He received a letter of acceptance on November 23. So here almost 5 months have gone. He refused to take the shares. It was held that M was entitled to refuse as his offer had lapsed, as the reasonable period during which it could be accepted had lapsed. Next legal rule, it must be given before the offer lapses or before the offer is withdrawn, that is before revocation of offer. And for this point already we have discussed the previous illustration that M offered to get shares of our company. Next, legal rule or essential: acceptance cannot be implied from silence. Acceptance cannot be implied from silence. Mental acceptance is not acceptance. There should be some external manifestation of acceptance. Means here the acceptor or the offeree must do something for communication of acceptance. So the acceptance of an offer cannot be implied from the silence of the offeree or his failure to answer, unless the offeree has, by his previous conduct, indicated that his silence means that he accepts. Example: A wrote to B, I offer you my car for rupees 1 lakh. If I don't hear from you in 7 days, I shall assume that you accept. B did not reply at all. So there is no contract because acceptance cannot be implied from silence. We will be discussing this illustrative case law, Feldhaus versus Bentley. Fact of the case: the complainant, Paul Feldhaus, he was uncle. He had conversation with his nephew, John Feldhaus, about buying the horse of his nephew. After their discussion, the uncle he offered by letter to buy B's horse for £30, stating that if he didn't hear any more from his nephew concerning the horse, he would consider acceptance of the offer or order done, and he would own the horse. Nephew did not reply to this letter and was busy at auctions. The defendant, Mr. Bentley, ran the auctions, and the nephew told Mr. Bentley or an auctioneer that not to sell the horse, that particular horse. However, by accident, he ended up selling the horse to someone else. The issue in this case was whether silence or a failure to reject an offer amount to acceptance. It was held that there was no contract for the horse between the complainant, that is between the uncle and his nephew. Mr. Bentley, an auctioneer, argued there was no valid contract for the horse since the nephew had not communicated his acceptance of the complainant's offer. There had not been an acceptance of the offer. Silence did not amount to acceptance, and an obligation cannot be imposed by another. Any acceptance of the offer must be communicated clearly. Although the nephew had intended to sell the horse to the complainant, that is to the uncle, and showed his interest, there was no contract of sale. Thus, the nephew's failure to respond to the complainant did not amount to an acceptance of his offer. Next rule or next essential as to acceptance: acceptance cannot be in ignorance of the offer. Acceptance cannot precede, or the acceptance cannot be before the offer. So acceptance cannot precede the offer, nor an acceptance in total ignorance of an offer result in a contract. For example, this is a case law, Lalman Shukla versus Gauri Datta. S offered a reward to anyone who returned his lost dog. F brought the dog to S without having heard of the offer. It was held that F was not entitled to the reward because F was unaware of the fact or unaware of the offer, and hence the question of acceptance never arose, because without having heard of the offer there cannot be acceptance. Here, if he did not heard the offer, so how he can give his acceptance? And therefore without having heard of the offer there can be no acceptance.